This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves, toll free at 1-888-962-0007. Again, that's 1-888-962-0007. Or go to www.reevesfirm.com.
Good day and welcome to another edition of Q&A Social Security Disability Today. I'm your host, Attorney Anthony Reeves. Let's get to your questions. What is a disability hearing officer, and is that like a judge? Okay, let me explain to you how a disability hearing officer comes up. Typically, disability hearing officers are employees of it depends on the various states, but typically the employees hooked on phonics, employees of the Division of Disability Determination. They're an employee who's responsible for having a informal hearing in cases where your benefits are, when you're challenging whether or not your current benefits should be discontinued. This happens under situations as what we call a cessation case, meaning you get a letter in the mail saying, hey, we believe that you're no longer disabled. You decide to appeal that. So then what happens is that you go before a disability hearing officer. It's a little different from the court, meaning you're not going in front of a judge. You're not going to, before dealing with experts and anything like that. You're usually going to go down to a state agency office. You'll sit in a room or sit at a desk across from an individual, and they have basically a booklet of information, and they have all of your medical information, and they're just going to probably spend about an hour, hour and a half asking you a variety of questions to make a determination about whether or not you are still disabled. Here is the magical threshold. They're trying to decide if you've medically improved. So how do they compare? Well, let's say you were found disabled in, February 2009. Now it's February 2013. What happens is they go, when you come up for a review, they go and they send out letters to your different doctors. They get more medical evidence from you. They have you send out forms. And then what they do is they take that file from 2009 and they compare it to the medical evidence of 2013. And what they're trying to see is if one of three things have happened. Has your condition remained the same, gotten better, or gotten worse? If it's remained the same, it's probably a fairly good bet that you're probably going to be continuing disability benefits. If it's gotten worse, it's probably a fairly good bet that your benefits will continue. The key is medically improved. If they believe that at the time that they do the review, which is now, that your condition is improved, then under the regulations, they have to now make a determination as, has that improvement gotten you to the point where you can now re-enter the workforce? Now, keep this in mind. They don't care about whether you apply for a job or anything, or whether no employer would hire you. The key is whether you physically and or mentally can perform a job based on your medical improvement. So what happens is that when you contest that, you go before a disability hearing officer who has those information before them. And they'll ask you a lot of questions, nothing really crazy. Like I said, it's very informal. And then they're going to make a determination of whether or not they think your condition is improved. Now, here's what you need to know if you're going before a disability hearing officer. And this is where it gets a little tricky. You want to make sure the file is current. And what I mean by current? Well, for instance, let's say that they've tried to get medical records from different doctors for you, but only a couple of them will provide. You better make sure that you contact those doctors to make sure that they provide those records to them. Because let's say that they try to get records from your neurologist and your neurologist didn't provide that information to them. When the neurologist is treating you for diabetes and diabetic neuropathy and retinopathy, and those records would show that you're still disabled, but they didn't get those records because the neurologist wouldn't provide them. Well, guess what? When they make that review, they may look at your records, and the records they have in hand may show you've medically improved, even though the records that are most relevant are not in the file. Now, you would say, that's messed up. Well, actually, no, it's not, because if they ask for the records from the doctor, and the doctor didn't provide them, they can't make the, well, they can, they get subpoena the records, but the reality is they get the release from you. You've given permission to the doctor to give your records to them. The doctor has chosen to not do so. And usually what ends up happening in situations like that, maybe the doctor had an invoice of like $100. Well, he wanted $100 for all these records, and Social Security says, we're not going to pay $100 for those records. And they were like, well, I'm not going to release them until you pay $100. Well, you're in a catch-22. That's why I tell people, listen, when you get a review coming up, call your doctors. Make sure you let them know, listen, if there's anything you can do to make sure that they have the records, please do so. Also, get there a little early and ask for the opportunity to review the file. And the reason why that's important is because maybe they asked for the records and the records just hadn't come through yet. So this way you can say, listen, before you make a decision, can you give me a day or two to go and get those extra records? You want to make sure your file is current when they're doing the disability hearing office review. Now, most people will say, well, what happens after that? Their decisions are fast. They usually will get you a decision within 3 to 4 weeks. So if they make a determination that you are still disabled, well, you're good. If they decide that you're not, you still have one more recourse. Well, you have a couple more, but the one that most people need to know is that if you disagree, you can then ask to go before a judge. And then it's just like it was before. You've got probably anywhere from about 11 to 12 months, maybe longer wait. You want to make sure you have medical records in there accordingly and make sure it's updated during that time period. But this is why I tell people, the disability hearing officer is not necessarily like a judge, but the way they're doing things is a little different. They want to see whether or not you've medically improved. Now, when you go before a judge, he or she is going to want to do the same thing. But to avoid the possibility of having to go that far, just make sure your file is current. Make sure you let your doctors know you're going through the review, and get there early to review your file so that you can make sure you have everything. And if you don't feel comfortable going by yourself, always contact a representative to go in with you. Again, this is a Q&A Social Security Disability Today. Stay tuned, and when we come back, we'll let you know what our next show will be about. On our next edition of Q&A Social Security Disability Today, we're going to talk about whether or not you can get disability benefits at the age of 45. Again, this is Anthony Reeves, and this is your Q&A Social Security Disability Today. Have a wonderful day.